the entire story that the public has believed for almost a year is not actually the story at all? What if beneath the surface of headlines, statements, and courtroom filings, there is a second narrative quietly forming, one that cannot be ignored, and one that no one is prepared for? Because everything that has unfolded so far may not be about what was said in public, but what was written in private. And what if the most important evidence in this case was not the dramatic testimony or the emotional interviews or even the flashy headlines, but instead the unseen messages exchanged behind the scenes, messages that now sit at the center of a legal battle that could change everything? And tonight, that unseen story begins to surface, slowly, methodically, and in a way that raises more questions than answers. Because the more you look at what has been disclosed and what has been sealed, the harder it becomes to separate perception from provable reality. And this is where the case takes a turn few expected, because at the heart of this dispute is not just what happened on a film set, but what was created in the space between professional boundaries and personal communication, when roles blur and interpretations differ. And what makes this moment so critical is that one side of this legal feud has placed its private messages into public view, while the other side now argues those same messages must remain hidden. And that contradiction alone has fueled intense speculation across the industry. Because if nothing within them changes the narrative, then why protect them with such force? And what if the true reason is not privacy at all, but impact? Because once a jury sees real-time conversations, tone, intent, and consistency, everything changes, and the entire case could pivot in a single afternoon. And that is why the current legal phase matters more than anything seen so far, because motions now before the court focus not on emotion, but on law, jurisdiction, standards of conduct, credibility, and whether what is alleged even meets the legal threshold required to proceed. And when judges analyze these motions, they do not weigh feelings, they weigh facts, context, patterns, and documentation. And this is where the battle becomes dangerous for both sides, because documentation does not interpret itself. It tells its own story, and sometimes that story conflicts with the narrative presented later. And that conflict is what now defines the strategic struggle behind closed doors, because the evaluation is no longer about isolated claims, but about the sequence of interactions that built the working relationship before, during, and after the moments now described as a rivalry. In legal filings, and what the documented timeline suggests is not a single explosive flashpoint, but a long, evolving exchange where tone shifted, comfort fluctuated, and expectations silently changed. And in legal analysis, that evolution matters, because harassment cases often hinge on whether conduct was unwelcome at the time it occurred, and whether boundaries were ever clearly established or consistently enforced. And this is where the messages now under dispute become pivotal, because when private messages reflect warmth, collaboration, encouragement, or even playful language at the same moments later described as intolerable, the legal evaluation becomes complex, and not in the way public opinion typically assumes, because courts do not operate on trending narratives. They operate on consistency, intent, and corroboration. And the moment consistency breaks, the ground beneath a claim begins to shake. And that shaking is what legal observers now believe could define the future of this case. Because even a single contradictory exchange can rapidly alter leverage during negotiations, motions, and potential settlements. And now consider the timing of what is happening, because while one lawsuit advanced with wide public disclosure, the other has aggressively pursued sealing of overlapping material. And courts generally frown upon selective transparency, especially when documents already exist in public filings elsewhere. And that creates an unusual dynamic, because once something is released into the public legal record, it cannot easily be erased from judicial awareness, even when later filings attempt to restrict its redistribution. And this leaves the court in a unique position where it has access to material that the public is now being told should not be seen. And that alone sparks deeper judicial scrutiny, not suspicion, but rigorous evaluation. Because transparency affects credibility, and credibility determines how testimony is weighed. And when credibility weakens, every surrounding allegation becomes harder to sustain and harder to defend, no matter which side one stands on. And this is why legal momentum has quietly shifted from emotion to analysis, from narrative to documentation, from shock value to procedural thresholds. And while headlines continue to focus on dramatic statements, the courtroom focus has become something far quieter, far more precise, and far more dangerous to any inconsistent account. Because this phase is where claims are either elevated into trial posture or quietly dismissed before ever reaching a jury. And summary judgment is one of the most powerful procedural gates in civil litigation, because it tests whether any genuine dispute of material fact even exists. And if the answer is no, the entire case can end without a single witness ever testifying. And that is the crossroads now approaching. And this is where private communication history becomes not background noise, but the centerpiece. Because when judges review these motions, they do not ask who appears more sympathetic. They ask whether a reasonable jury could legally find for the claimant based on the evidence,
as it objectively exists. And if that standard is not met, the case ends regardless of public reaction. And this is why the push to seal becomes strategically logical, not because nothing exists, but because what exists may not serve the claim in the way originally envisioned. And when legal strategy shifts from exposure to containment, it signals that what is behind the curtain carries real influence. And that influence is what both sides now maneuver around cautiously, calculating each procedural step, because one ruling could unlock further disclosures or lock crucial doors permanently. And when courts confront selective secrecy paired with prior publication, the likelihood of judicial pushback increases, because fairness in litigation demands equal access to contested material and equal ability to test its meaning. And when one side seeks to limit that balance, arguments intensify, not emotionally, but structurally. And this is how cases are truly won and lost, not through headlines, but through rulings on motions few outside the legal field fully understand. And as this case advances deeper into that procedural arena, the spectacle slowly fades and structure takes over. And that structure is indifferent to fame, influence, or narrative dominance. It rewards only alignment between pleading and proof. And that is why the next phase carries more risk than any interview, any social posts, or any public statement, because the protections of the media cycle vanish inside courtroom procedure, and only sworn statements and verified records remain. And that is where the outcome will ultimately be decided. And that is why every single text, every timestamp, every phrase now matters more than ever before. And that brings us to the moment everyone assumed mattered least, but may now matter most. The earliest exchanges where tone was set, boundaries were negotiated, and professional comfort was mutually constructed. Because those early moments established the baseline from which later discomfort must be measured. And without that baseline, claims lose dimensional context, and courts demand that context to properly evaluate liability. And once that context enters judicial analysis, its influence is permanent, not temporary. And it is already shaping how this case is being evaluated at its core. And the further this scrutiny progresses, the more it appears that the battle no longer centers on a singular incident, but on the transformation of perception across time. And in law, transformation alone does not equal violation. It must be tied to demonstrable, unwelcome conduct post-boundary establishment. And without that linkage, causation weakens and claims fracture. And the closer this case moves toward that analytical threshold,
the louder the silence becomes, not in the media, but in filings, where language tightens, arguments narrow, and positions harden. Because each side understands that once the judge rules, there is no editorial spin that can undo it. And this is why the next document, unsealed or sealed, may shift the entire legal trajectory in a single ruling, and why what seems hidden today may soon become unavoidable tomorrow. And that reality alone reshapes leverage expectations and settlement dynamics quietly behind closed doors while public debate rages outside. And as this legal chess match continues, every move now serves a future ruling, not an immediate headline. And that is why the focus has moved toward suppression, expansion, and procedural positioning rather than public explanation. Because in the end, only one version must survive the law, not public opinion. And that is where this case is now headed, whether anyone is truly ready for what that means or not. And as that direction becomes unavoidable, the most unpredictable factor is not what has already been said, but what still remains unresolved. And that unresolved layer is what prevents any version of this story from fully settling. And that tension is precisely why the next stage of this case will feel nothing like the last, and why the moment of true disruption has not yet occurred. And when it does, it will arrive without warning, without commentary, and without a press release. Just a ruling. And everything after that changes.
And so what began as a story driven by headlines and perception now returns to the quiet place where outcomes are truly decided, inside sealed filings, judicial review, and the cold measurement of consistency over time. Because in the end, it will not be interviews, speculation, or public reaction that determines what survives, but the alignment between law and evidence. And the further this case travels down that path, the clearer it becomes that the most powerful force shaping the result is not what was said out loud, but what was written in moments when no one expected the words would ever carry this much weight. Because private communication does not live in isolation forever. It eventually finds a spotlight when motive, intent, and interpretation are tested. And once that happens, narratives shift, not gradually, but suddenly. And this is why the final chapter of this case has not yet arrived, because the moment that defines everything still sits ahead, waiting on a ruling that no public campaign can influence. And when that ruling comes, there will be no rewind, no reframing, and no retelling that alters its impact, only acceptance and aftermath. And while the world continues debating what it believes, the courtroom will quietly decide what can be proven. And that difference between belief and proof is where the real tension now lives. Because belief changes daily, but proof endures permanently. And as both sides prepare for what may be the most consequential phase yet, the silence between filings grows heavier. Because silence in law is rarely empty. It is loaded with intention, positioning, and anticipation. And the next disclosure or decision will not simply add another chapter. It will redefine everything that came before. And that is why this story is not ending. It is tightening. And the closer it pulls, the more unstable the ground becomes beneath every assumption made so far. And when the truth of what truly holds up under scrutiny finally emerges, it will not arrive loudly, but it will be felt instantly. And when it does, the entire narrative will either stand or collapse in a single moment. And the most unsettling part is that no one watching now can be fully certain which outcome is closer, because the answer has been there all along, waiting inside the very messages that started everything. And that brings us right back to where this began, with what was said when no one thought anyone else would ever see it.